Namaskar and good evening to all respected members of Akhil Bhartiya Adhivakta Parishad Devgiri Prant, learned advocates, judicial services aspirants, and dear friends. Today's session is a special and emotional occasion for all of us because we are attending this concluding lecture of this valuable series on the Civil Procedure Code delivered by our respected guide, Shri Sandeep Munde sir. During the entire lecture series, sir has not only explained the law but has made a difficult subject like Civil Procedure Code simple, practical, and interesting for all of us. Though his clear teaching, practical examples, and explanations in both English and Marathi, Sir made every topic easy to understand. The most important thing about this series is that Sir conducted these lectures with only one noble intention that good judges should emerge from amongst all of us in the future. This selfless effort and dedication to our judicial aspirants truly deserves our sincere respect and gratitude. Every lecture of Sir reflects his deep knowledge, vast judicial experience, and practical understanding of courtroom procedure. His guidance has greatly benefited all aspirants preparing for district judge and JMFC civil judge junior division examination. In today's time, such sincere and dedicated guidance is rare. Sir's continuous effort for a legal fraternity and judicial aspirants are truly inspiring. On behalf of Akhil Bhartiya Adhivakta Parishad Devgiri Prant and all the aspirants present here, I express our heartfelt gratitude and warm regards to the respected Sandeep Munde sir for giving his valuable time and sharing his precious knowledge with all of us. Sir, your guidance and encouragement will continue to inspire us even after this lecture series. Now, with great respect and honor, I humbly request respected Sri Sandeep Munde sir to deliver today's concluding lecture.
Thank you. Good evening to all. So, friends, as per the first introductory lecture, we have decided to discuss the Code of Civil Procedure into 4 parts. The first part contains from the section 1 to section 35 and order 1 to order 20, which deals with regards to the filing of the suit up to the passing of judgment and decree. Second part, which we have discussed as the execution part, the party in whose favor the decree will pass, he will opt for the execution of proceeding, which we have discussed from section 36 to 74 and order 21. Then after, in the last session, we have discussed the incidental proceedings or the suits in particular cases or the special proceedings and the supplemental proceedings, which starts with the section 75 to 95 and order 22 to order 40. So in the fourth part, which we have to discuss, what about those persons against whom the judgment or the decree has been passed by the court of law. So the next term which we have to discuss in today's lecture, that is the term of appeal. Along with the appeal, in today's lecture, we have to discuss what is the concept of reference, review, and revision. And lastly, in the miscellaneous part, we have to discuss the provisions with regards to the restitution, as well as the concept of caveat and savings of inherent powers of the court. So, in today's lecture, firstly, we will discuss from section 96 to 99A and order 41, which deals with regards to the appeals from original decree. Then section 100 to 103 and order 42, appeal from appellate decree. Then section 104 to 106 and order 43, appeal from order. Order 44 deals with regards to the appeal by indigent person, and section 109 to 112 and the order 45 deals with regards to the appeal to the Supreme Court. The provisions of section 107 and 108 deals with regards to the general provisions relating to the appeal. So section 113 and order 46 deals with regard to the reference to the High Court, in which contingencies, in which cases the court may refer the case to the High Court. Then the concept of a review under section 114 and order 47, and lastly, when what in which circumstances the concept of revision can be applied according to the section 115 of the Code of Civil Procedure. So, firstly, if again we come to the definition clause, if we see the definition clause, in the definition clause, there was no cover to the what is the definition of appeal. So, though under section 12.2 of the Code of Civil Procedure, there is definition of appeal has not been mentioned. But what is the exact meaning of appeal? So in terms of Kabir, I will say, कबीर कहे इस दुनिया में सबसे सुखी वकील, जीत गए तो वाह वाह, हार गए तो अपील. It means who will files the appeal? Appeal will be filed by the aggrieved persons against whom the judgment or the decree or the order has been passed. So the person in whose favor decree or the order will pass, he will opt to go for the execution proceeding. Why he will file the appeal? So one of the essential ingredient for the filing of the appeal, that who may file an appeal, the aggrieved party against whom the order has been made, he will file an appeal. So the next question will be, where to file an appeal? Can the appeal goes before the same court? No, appeal always go before the superior court. So what are the rules for filing of the appeal? As we have already discussed the rules for framing of the plaint, what things are needs to be included, what things are not cannot be included into the plaint, as well as the at the time of discussing of the pleadings, whether that rules will be applicable to the appeal. So whether the appeal is a statutory right or the fundamental right, it is a creature of the statute. Appeal is the creature of the statute. So in these provisions under the Code of Civil Procedure, particularly from section 96 to 109 and order 41 to order 45 deals with regards to the different kinds of appeal before the civil courts. It also includes from the first appellate court up to the appeal up to the Supreme Court of India. So, what is the meaning of appeal? Though it has not been defined under the Code of Civil Procedure, according to the dictionary meaning of appeal is the judicial examination of the decision by a higher court of the decision of an inferior court. In other language, it is the complaint or rather a grievance raised by the parties with the judgment or the order passed by an inferior court before an superior court. So, appeal is a proceeding by which defeated party approaches a higher authority or a court to have the decision of a lower court or court reverse. So, what are the essential things for the appeal? First at all, there should be a decision. There should be the order, there should be the judgment, or there should be the decree. And second thing, a person aggrieved. There should be the aggrieved person. And third, a reviewing body ready and willing to entertain an appeal. So, this is what the basic introduction with regards to the appeal. So, if a defeated party, aggrieved party, may challenge the decision of an inferior court before the superior court by filing an appeal. So in which, firstly, there are three kinds of appeals. The first one is the appeal from original decree. If any decree which has been passed by the court by exercising original jurisdiction, that can be an original decree. Second kind of appeal is the appeal from appellate decree. When the appellate court has entertaining by appeal, if the decree has been passed, it will be the appeal from original decree that will be covered under Order 42 and Section 100. We know the appeal from appellate decree always lies before the High Court. That is the concept of second appeal. Section 100 states with regards to the second appeal, and every second appeal is required to be filed before the High Court. Third thing, that is the order 43 deals with regards to the appeal from order. As in the definition clause we have already discussed, those orders which are not decrees that can be considered as a order. So whatever not covered as a decree, that can be appeal, and if it has been mentioned in section 103 and order 423, that will lie as an appeal from an order. The fourth one, order 44, is to some extent different kind of appeal that contains with regards to the appeal by indigent person. We have already discussed in the last lecture provisions with regards to the suit by indigent person, that will be continued for order 44. 45 order 45 deals with regards to the appeal to the Supreme Court. These are the provisions with regards to the appeal. Now we will discuss in detail what are that provisions. First at all, we will discuss from section 96 to 99A and order 41. In order 41, there are total 37 rules are there. So first at all, what is the concept of appeals from original decree? Section 96 reads, save where otherwise expressly provided in the body of this code or by any law for the time being in force, an appeal shall lie from every decree. Appeal shall lie from every decree passed by any court exercising original jurisdiction to the court authorized to hear appeals from the decision of such a court. In 96 subsection 1, every decree passed by the original jurisdiction court is appealable, can be filed in the appeal. Second, an appeal may lie from original decree passed ex parte. If the decision in suit is ex parte, also appeal lie. 3. No appeal shall lie from a decree passed by the court with the consent of parties. If the decree has been passed by the court on the consent of the parties, from that decree, appeal is prohibited, no appeal will lie. And fourth, no appeal shall lie except on a question of law from a decree in any suit of the nature cognizable by courts of small causes, when the amount or value of the subject matter of the original suit does not exceed 10,000 rupees, provision will be applicable for the small causes suit. 96.4. So every decree is available. Even from the ex parte decree, appeal will lie, but from the consent decree, appeal will not lie. Section 97, appeal from final decree, where no appeal from preliminary decree. So practice after some of the amendments, practice of passing of the preliminary decree and the final decree has been abolished. But if where a party agreed by a preliminary decree passed after the commencement of this court does not appeal from such a decree, he shall be precluded from disputing its correctness in appeal, which may be preferred from the final decree. If you have admitted the preliminary decree, at the time of challenging the final decree, you cannot dispute or raise the dispute with regards to the preliminary decree. Section 98 reads, decision where appeal heard by 2 or more judges, majority will prevail, and that can be a binding force. 99, no decree to be reversed or modified for error or irregularity not affecting merits of the jurisdiction. As we have already discussed at the time of place of filing, place of suing, if the decree has been passed without jurisdiction, it will be nullity. But if there is no any objection, or if we peruse the wording of the section 99, it states, no decree shall be reversed or substantially varied, nor shall any case be remanded in appeal on account of misjoinder or non-joinder of parties, or of cause of action, or any error, defect, or irregularity in a proceedings in the suit, not affecting the merits of the case or the jurisdiction of the court. Because there already it is being stated, if you have any objection with regards to the parties or a cause of action or a jurisdiction, you have to raise it as early as possible and at the earliest possible opportunity on or before framing of the issue. Therefore, it has been stated appeal will not affect or decree cannot be reversed only on that ground. 99A, no order under section 47 to be reversed or modified unless decision of the case is prejudicially affected. In the last lecture, we have discussed the 47. All the questions arises in the execution proceeding has to be decided by the executing court without prejudice to the generality of the provisions of section 99. No order section 47 shall be reversed or substantially varied on account of any error, defect, or irregularity in the proceedings relating to such order. So these are the general provisions with regards to the appeal from original decree. This is one of the things from which decrees appeal will lie and from which decrees appeal will not. It has been mentioned in section 96. 97, if there is no appeal from preliminary decree, you cannot dispute it into the appeal into the final decree. 99, it cannot be reversed if it has not been earlier objected. 99A deals with regards to the 47 of the Code of Civil Procedure. Now, we have to go with the order 41, which deals with regards to the appeal from original decree and the basic proceeding which has been mentioned with regards to the appeal from original decrees. So, what should be the form of appeal? What is the concept of memorandum of appeal? What should be the contents of appeal? What should be the grounds which may be taken into the appeal? Before which court appeal will lie? That name of the court, name of the parties, who may file an appeal, who should be the parties to the appeal, and all these things. What are the rights and the duties of the appellate court? What are the rights of the parties with regards to the filing of the appeal? It has been mentioned in order 41, in which there are total 37 rules are there in order 41. So, rule 1 states, form of appeal, what to accompany memorandum. What documents are required to be accompanied with the memorandum? Every appeal shall be preferred in the form of memorandum signed by the appellant or his pleader and presented to the court or to such officer as it appoints in this behalf. The memorandum shall be accompanied by a copy of judgment. So, what is the basic ingredients which requires to be accompanied with the appeal? That is, the judgment is required to be produced before the court of law. What is the contents of memorandum? Memorandum shall set forth concisely and under the distinct heads the grounds of objection to the decree appealed from without any argument or narrative, and such a ground shall be numbered consecutively. So, in order 6, we have to discuss in the pleading, you have to state facts only, not the law, not the evidence. In appeal, you have to state the grounds of appeal or the objections to the decree appealed from. There should not be the argument or the narrative, and whatever you are raising the grounds, it is required to be numbered consecutively. Where an appeal is against the decree for payment of money, the appellant shall within such time the appellate court may allow deposit the amount. If there is a decree for recovery of money, certain amount is required to be mentioned. Rule 2, grounds which may be taken in the appeal. So whatever the grounds you have raised into the appeal memo, you may argue it. Except the leave of the court, argue or heard in the support of any ground of the objection not set forth in the memorandum of appeal, but the appellate court in deciding the appeal shall not be confined to the grounds of objection. Rule 3, rejection or amendment of memorandum. After that, court may allow to reject or amend the grounds. Application for condonation of dealing. So, there was no limitation has been provided under the Code of Civil Procedure for preparing an appeal before the appellate courts. But according to the provisions of Limitation Act, the appeal period for filing the appeal before the High Court is of 30 days and for other court is of 90 days period has been prescribed. But after 3A states when an appeal is presented after the expiry of the period of limitation specified therefore, it shall be accompanied by an application supported by affidavit setting forth the facts on which the appellant relies to satisfy the court that he had a sufficient cause for not preferring an appeal within such a period. If there is barred by limitation, then you may file the application seeking condonation of delay along with the appeal, but that application affidavit is required, and for appeal, no affidavit is required, only just the sign of appellant or his pleader is sufficient. One of several plaintiffs or defendants may obtain reversal of whole decree where it proceeds on the ground to common to all. If whatever the effect of it will be applicable to all. Stay of proceeding and of execution. Stay by appellate court. Mere filing of the appeal or presentation of appeal before the appellate court not amounts to the stay of the execution proceeding or the decree passed by the inferior court unless and until court has granted specific order with regards to the stay by which the court will pass. Unless and until that order, it is not operate as a stay to the execution proceeding or the stay to the judgment. Rule 6, security in case of order for execution of decree appealed from, court may ask to deposit the security. 8, exercise of powers in appeal from an order in execution of decree. So whatever the conferred by the rules 5 and 6 shall be exercisable wherein an appeal may be or has been preferred not from the decree but from an order made in the execution of the decree, it can be entered in. So after the presentation of the appeal, there will be what is the next procedure on admission of the appeal. If as per the whatever the contents, whatever the memorandum of appeal, whatever the form of appeal, if the appeal has been presented before the court of law and court admits it, what is the according to the rule 9, registry of memorandum of appeal, the officer of the court will register it as an appeal. If it has been presented, the district court will be registered it as a regular civil appeal or the first appeal as the case may be required. Then appellate court may require appellant to furnish security for cost where appellant resides out of. 11, power to dismiss appeal without sending notice to the lower. If the appeal has been preferred against the decree and the court has found that there was, after hearing to the learned counsel for the appellant or his pleader and hearing him accordingly, if he appears on that day, may dismiss the appeal. So without issuing notice to the respondents or without giving notice to the lower court, according to the rule 11, the court has the power to dismiss appeal without sending notice to the lower court. 11A, time within which hearing under Rule 11 should be concluded. Every appeal shall be heard under Rule 11 as expeditiously as possible, and endeavor shall be made to conclude such a hearing within 60 days from the date on which memorandum of appeal has been filed. So the first date of appeal is required to be concluded within a period of 60 days as mentioned in Rule 11A. Day of hearing appeal, such a day shall be fixed with reference to the current business of the concerned appellate court. 14, publication and service of notice of day for hearing of appeal. If the court thinks that there has substance and it is required to be heard by the respondent, court will issue the notice. And what is the procedure for the issuance of notice to the respondent? That appellate court may itself cause notice to be served, or it can be served through directly upon the respondents through the said trial court. So once the admission appeal has been admitted, notices has been given to both the respondent side. So what is thereafter, the next is with regards to the procedure on hearing. So as we know, the right to begin on the day fixed or on the day or any other day to which the hearing may be adjourned, appellant shall be heard in support of the appeal. Court shall then, if it does not dismiss the appeal at once, hear the respondent against the appeal, and in such a case, appellant shall be entitled to reply. Who will be right to begin? It is always appellant has a right to begin according to the rule 16. Dismiss of appeal for appellant default. The court has a power to pass an order of dismissal in default if there is a default on the part of appellant. Hearing appeal ex parte. Though the notice has been served, duly served upon the respondent and does not appear, court has a right to hear the appeal on merits ex parte. 19 again come to the said point, readmission of appeal dismissed for default. If it has been said, court may restore it. 20 power to adjourn hearing and direct persons appearing interested to be made respondent. Where the court is appealed that the hearing that any person who was a party to the suit in the court from the which decree the appeal is preferred, but who has not been made a party to the appeal. So, who will be the party to the appeal? All the parties who are parties to the suit are essential and requires to be made as a party respondents or the party appellant in the said suit. All parties to the suit should be the parties in the appeal. 21 again, rehearing on application of the respondent against whom the ex parte decree made, court will heard it. Upon hearing, respondent may object to decree as if had been preferred separate appeal. It will be the right to of the said respondent to raise the objection to the said appeal. Form of objection and provisions applicable thereto. Such a cross objection shall be in the form of memorandum and the provisions of Rule 1 so far as they relate to the form and contents of the memorandum of appeal shall apply thereto. So, Rule 22 is the provision with regards to the cross objection or the cross appeal by the respondent against the appellate. This will probably in the many matters will be filed with regards to the land acquisition cases. When the state will prefer the appeal against the claimant, then the claimant should file the ex objection or the cross objection against the said decree before the same court. So it is like as a cross suit or the cross complaint or as a counter claim which we have discussed in the order 8. So it is the concept of cross appeal or the cross objection under Rule 22. So what are the powers of the appellate court? So the first power that the remand of case by the appellate. After hearing both the sides, if the court finds that something has been missing, court has a power to remand the matter back for fresh consideration. Remand in other cases. 24, where evidence on record sufficient, appellate court may determine case finally. So the second power of the appellate court to decide the case finally. No, appellate court cannot remand each and every case. If the court is of the opinion that there is a sufficient evidence has been recorded, court will decide the case finally. 25. Where appellate court may frame issue and refer them for trial to the court who the decree appealed from. In such circumstances, therefore, I have already told you, the issues are the backbone of the case, and for the right decision, proper issues are required to be framed. If the appellate court is of the opinion that issues are required to be framed, the appellate court may frame the issue and direct the trial court to take the evidence with regards to it. 26. Findings and evidence to be put on record, objection to the finding, determination of appeal, and 26A, order of remand to mention date of next hearing. If the court has remanded matter back, the court will give the date to the concerned parties. So, at the time of discussing order 14, 15, 16, or 18, I have told you whatever evidence you have to require to be produced, you have to produce before the trial court. But under some circumstances, under exceptional circumstances, whether the appellate court has a power to take the additional evidence. So, according to the Rule 27, production of additional evidence in appellate court. So, the parties to an appeal shall not be entitled to produce additional evidence, whether oral or documentary in the appellate court. But if the court from which decree the appeal is prepared has refused to admit the evidence which ought to have been admitted, A, the party seeking to produce additional evidence established notwithstanding the exercise of due diligence, such evidence was not within his knowledge or could not after the exercise of due diligence be produced by him at the time when the decree appealed against was passed, or the appellate court requires any document to be produced or any witness to be examined to enable it to pronounce judgment, or for any other substantial cause, appellate court may allow such evidence or document to be produced or witness to be examined. And whenever the additional evidence is allowed to be produced by the appellate court, court shall record the reasons for its admission. So, the opening of the section 27 is that parties to an appeal shall not be entitled to produce the additional evidence, but whatever the exceptions which have been carved out under Rule 27, in that contingencies, the appellate court may take the additional evidence from the parties. Mode of taking evidence will be the same, points to be defined and recorded. So, what will be the judgment in appeal? We have already discussed the Order 20 and Section 34-33, which deals with regards to the judgment and decree. So, what are the essential things which are required to be mentioned in the judgment in appeal? Rule 30 states, judgment when and where pronounced. So, the appellate court, after hearing the parties or their pleaders and referring to any part of the proceedings, whether an appeal or in the court from whose decree the appeal is prepared, to which reference may be considered necessary, shall pronounce judgment in open court at either at once or on some future day, of which notice shall be given to the parties. Meaning thereby, after hearing of the appeal, the appellate court may pronounce the judgment in the open court. 31 contains date and signature of the judgment, as like the judgment under Order 20. What should be the points for determination, the decision thereon, the reasons for the decision, where the decree appealed from is reverse or valid, the relief to which the appellant is entitled, all the things are required to be mentioned in the judgment. What judgment may direct needs to be specifically stated. The power of court of appeal and dissent to be recorded. When there is the judgment which has been heard, the case appeal which has been heard by more than one judges, and any judge descending from the judgment of the court shall state in the writing the decision or order which he thinks should be passed on appeal, and he may state his reasons for the same. It will be when there are the judges in some number, even number, and if we are descending, then will be applicable. Decree in appeal, date and contents of decree needs to be mentioned. Copies of judgment needs to be furnished to the parties, and certified copy of decree to be sent to the court whose decree appealed from. Meaning thereby, the crux of the Order 41 appeal from original decree is that who should be the party to the same, what should be the contents of the appeal, and what is the limitation period for filing of the appeal before the appellate court from the original decree, and what is the contents of the judgment and the decree are required to be seen from Order 41 and from Section 96 to 91. It covers appeal from original decree. Now, whatever these rules of the appeal from original decree are applicable to next all provisions of the appeals. So, in Order 42, there are only 3 rules. Only the important section of the same is Section 100, which reads that, what is the Section 100? Section 100 states, second appeal. Save as otherwise provided in the body of this code or by any other law for the time being forced, an appeal shall lie to the High Court. Every second appeal will lie to the High Court from every decree passed in appeal. Every decree passed in appeal by a court subordinate to the High Court, if the High Court is satisfied that case involves a substantial question of law. Once we uttered the word second appeal, we should know the word substantial question of law. The High Court will entertain only the decree passed by the appellate court who is subordinate to the High Court when in that case substantial question of law has been involved. Subsection 2, an appeal may lie under this section from an appellate decree passed ex parte. In an appeal under this section, the memorandum of appeal shall precisely state the substantial question of law involved in the appeal. Therefore, in the draft of second appeal, you have to mention these are the substantial question of law involved in the said appeal. Fifth, The appeal shall be heard on the question so formulated, and the respondent shall at the hearing of the appeal be allowed to argue that case does not involve such questions. 100A reads, no further appeal in certain cases. In which cases the no further appeal? Where an appeal from an original decree or appellate decree or order is heard and decided by a single judge of a high court, no further appeal shall lie from the judgment and the decree of the such a single judge. No further appeal, LCA, letter patent appeal, has been abolished from single judge. No appeal will lie before the division bench. Second appeal on no other grounds. No second appeal shall lie except on the grounds mentioned in section 100 and 102 section reads, no second appeal in certain cases. No second appeal shall lie from any decree when the subject matter of original suit is for recovery of money not exceeding 25,000 rupees. If the suit is for recovery of money and the subject matter is below 25,000, second appeal will not be entertained. And the 103, power of High Court to determine issue of fact. So in any second appeal, the High Court may, if the evidence on the record is sufficient, determine any issue necessary for the disposal of appeal, which has not been determined by the lower appellate court or both by the court for first instance and the lower appellate court, which has been wrongly determined by such court or courts by the reason of decision on such question of law as referred to in section 100. So basically, if there was any question with regards to the appeal from appellate decree, you should remember two things. The first thing, that the order 41, section 100. Second thing, which deals with regards to the second appeal always lie before the High Court, and second appeal can only be entertained if there is the involvement of the substantial question of law. And in the draft of second appeal, you have to mention the what substantial question of laws are involved in that matter. Second appeal cannot be entertained on any other grounds except the substantial question of law. So only three rules are there in order 42. Procedure, whatever the procedure of order 41 shall be applicable. Power of court to direct the appeal be heard on the question formulated by it. Third, application of rule 14 of order 41. So entire procedure deal, whichever there in the order 41 is applicable to order 42, appeals from appelling decree. Now the next order is order 43, appeals from order. From which orders? Because earlier two orders covers the appeal from original decree. Order 42 covers appeal from appellate decree. Whichever orders which are not decrees, from them, whatever appeal will lies, that is the appeal from orders. So section 104 reads appeal from orders. Section 104, orders from which appeal lies. In section 104, the order under section 35A, order under section 91 or 92, refusing or granting permission, order under section 95, supplemental proceedings, and any order made under the rules from which an appeal is expressly allowed by the rules, from that it will be appeal can lie from the appeal from order which has been specifically mentioned either under section 104 or order 43 rule 1. So 105 other orders. 106 states what courts to hear appeals. I have already told the appeal from original decree has to be heard by the appellate court. Appeal from appellate decree has to be heard by the High Court. So if there is the appeal from order, which court have a jurisdiction to heard it? Section 106 states what courts to hear appeals. Where an appeal from an order is allowed, it shall lie to the court to which an appeal would lie from the decree in the suit. From where the appeal would lie from the decree, before the same court, appeal from order lies. So under order 43, rule 1, they specifically given the provisions under the Code of Civil Procedure. From the said provisions only, appeal from order will lie. The first thing, an order under Rule 10 of Order 7, return of plaint. When the court returns the plaint. A. C. Order under Rule 9, rejecting an application for an order to set aside dismissal of the suit. Order 9. D. Order 9, Rule 13, rejecting application to heard ex parte. F. Order 11, Rule 21, discovery and inspection. Order 21, Rule 34, objection to the draft. Order 21, Rule 72 or 92 in the execution proceeding. JA. Order rejecting application under sub-rule 1 of Rule 106 of Order 21, execution proceeding. K. Rule 9 of Order 22, abatement of proceeding. Order 22, Rule 10, refusing to give the leave. These are the certain provisions which has been mentioned in Order 43, Rule 1. Only from that provisions, appeal from order would lie. If there is a suit with regards to the interpleader suit under Order 35, when order under Rule 2, Rule 3 or Rule 6 of the Order 38, and order under Rule 1, 2 or 2A, Rule 4 or 10 of the Order 39, Order 40, Order 41 to readmit when the court reminds the matter back, and lastly, under Order Rule 23 or 23 of Order 21, remanding a case. Only in these contingencies, the appeal from order would lie before the appellate court, where ordinarily decree would lie before the said appellate court. You may file the appeal from order only if any order has been passed in view of these provisions of the Code of Civil Procedure. 1A, right to challenge non-applicable orders in the appeal against decrees, and the Rule 2, procedure. The rules of Order 41 shall apply so far as may be to the appeals from orders, whatever the procedure of Order 41 is applicable. Order 44, appeal by the indigent person, that all the provisions of suit by indigent person, that is Order 33, will be applicable in these provisions of Order 44. Now, we will see the section 107 and 108, which deals with regards to the general provisions relating to the appeals. What are the powers of appellate court? That the subject to such conditions and the limitations may be prescribed, appellate court shall have a power to determine case finally, B, to remand a case, C, to frame issue and refer them for trial, and D, to take additional evidence or to require such evidence to be taken. So what is the rule? Section 108, procedure in appeals from appellate decrees and orders. The provisions of this part relating to the appeals from original decrees shall, so far as may be applied to the appeals. So these are the general powers of the appellate court, section 107 and 108. Now, the section 109 deals with regards to the appeals to the Supreme Court. When appeal lies to the Supreme Court, subject to the provisions of Chapter 4 of the Part 5 of the Constitution, and such rules as from time to time be made by the Supreme Court regarding the appeals from the courts of India, and to the provisions hereinafter contained, an appeal shall lie to the Supreme Court from any judgment, decree or final order in a civil proceedings of the High Courts, if the High Court certifies. First of all, what is the first requirement? That whatever the judgment decree has to be passed by the High Court certified that the case involves a substantial question of law of general importance, and that in the opinion of the High Court, the said question needs to be decided by the Supreme Court in view of the section 109 and Order 45, appeal would lie to the Supreme Court. Now, we will move from the appeal part towards the order part. The next part, in which we have to discuss three concepts which are as like the nature of the appeal, but which has not been termed as a appeal. So, what are these provisions? You heard the provisions with regards to the reference, review, and revision. So, how to keep in mind the provisions of whether the reference is earlier or the review is earlier or the review is earlier. I will keep in mind the alphabetical sequence of the section 113, 114 and 115. 113 deals with regards to the reference REFE. Second, thereafter, the concept of section 114 is the review REVIEW. And third one, section 115, that is the revision REVISION. So there should not be the confusion under section 113, 114 and 115. Keep in mind alphabetically who will come first, reference will come first, review will be second and revision will be third. So section 113 deals with regards to the reference to the High Court. So section 113 order 46 deals with regards to the what is the concept of reference. Subject to such conditions and the limitations as may be prescribed by any court, may state a case and refer the same for the opinion of the High Court, and the High Court may make such order thereon as it deems fit. If any other court is of the opinion that the reference is required to be made to the High Court, in view of the provision of 113, any court may refer it to the High Court, that is known as a reference. So, Rule 1 states where reference to question to the High Court, where before or on the hearing of the suit or an appeal in which the decree is not subject to appeal, or where in the execution of any such decree any question of law in which contingencies court may refer the questions to the High Court as a reference, any question of law or usage having the force of law arises on which the court trying the suit or appeal or executing the decree entertains reasonable doubt, the court may either of its own motion. How to make the reference? Court has the power to make the reference either of its own motion or on the application of any of the parties, draw up a statement of the facts of the case and the points on which the doubt is entertained, and refer such statement with its opinion on the point for the decision of the High Court. So the provision of reference is applicable to entire proceedings. During pendency of the proceedings, it can be referred to the High Court as a reference. Court may pass decree contingent upon decision of the High Court. Whatever decision of High Court will be binding. Judgment of High Court to be transmitted and case be disposed of accordingly. Whatever the decision be given to the cost of reference to the High Court. Power to alter etc. decree of the court making reference. Power to refer High Court question as to the jurisdiction in small causes. These are the provisions with regard to the reference. When such a question of law arises which has not been decided by the Constitutional Court, and if the any other court is of opinion that it is required to be that question is required to be decided by the High Court, then in view of the provisions of section 113 and order 46, it can be referred the said question to the High Court by pointing out what are the points involved in it, and whatever the decision of the High Court in that reference will be binding on the parties as well as to that suit or any other. The next concept is the section 114 and order 47, that is review. There is the concept of view. View means to see, and review to see again. Whatever the decision which has been already been given by the court, in which contingencies court has a power to review its own decision. Whatever the provisions of the appeal, reference or the revision will lie before the other court. Generally, it will lie before the appellate. A review is the concept under the Code of Civil Procedure where it is the concerned party, aggrieved party will approach before the same court. It is the rule of the review that the review has to be decided by the same court, same judge. Section 114 reads, subject as aforesaid any person considering himself aggrieved, by a decree or order from which an appeal is allowed by this court but from which no appeal has been preferred, by a decree or order from which no appeal is allowed by this court, and C, by a decision of a reference from the court of small causes, may apply for a review of the judgment to the court which passed the decree. The court which passed the decree or made the order, and the court may make such order thereon as it thinks fit. So, in which contingencies court may, the aggrieved party may approach to the same court by filing a review that rules have been given under Order 47. Form of application for review, it will be as like the appeal. Application where rejected, it will go application where granted. Rule 5 state application for review in court consisting of 2 or more judges. It should be heard by the same. Application where rejected, order of rejection not appealable, objection to order granting an application. Bar to certain application, no application to review an order made an application for a review or a decree or order passed or made on a review shall be entertained. But the question is that on which ground court may entertain the review application. So, the first thing, whatever we have read from 114 that has been reproduced in Rule 1, and who from the discovery of new and important matter or the evidence which, on which ground the court, the aggrieved party may file a review or the court may entertain, from the discovery of new and important matter or evidence which after the exercise of due diligence was not within the knowledge or could not be produced by him at the time when the decree was passed or order made, or on account of some mistake, or it is the most important concept under the review that are error apparent on the face of record or for any other sufficient reason desires to obtain a review of the decree passed or an order made against him may apply for a review of judgment to the court which passed the decree or made the order. So where there is the discovery of new and important matter or the evidence, where it is not there due to, though there is the exercise of due diligence, if it is found that there is error or the mistake or error apparent on the face of record, only in that contingencies court has a power to entertain the review. It is also ruled that the review court is not sitting as an appellate on his own decree. Therefore, there is a very limited scope to the review. You cannot exercise the appellate court jurisdiction by deciding the review application. So, the next thing is the section 115 is the revision. Whatever which is not covered under appeal from original decree, appeal from appellate decree, appeal from order, where all the provisions bars the appeal, in that contingencies, the section 115 will be helpful. It reads with regards to the concept of revision. The High Court may call for the record of any case which has been decided by any court subordinate to such a High Court and which no appeal lies there. What is the condition for the revision? From which no appeal lies there to, and if such subordinate court appears, on what ground the revision can be entertained, to have exercised the jurisdiction not vested in it by law. Order has been passed without jurisdiction. B, to have failed to exercise jurisdiction so vested, though the court has jurisdiction, but it has not been exercised. C, to have acted in the exercise of its jurisdiction illegally or with material irregularity. The High Court may make such order in a case as it thinks fit. This is the revisionary power of the High Courts with regards to the revision which can be entertained under section 115 of the Code of Civil Procedure. Now, we have concluded the appellate part as well as the concept of reference, review, and revision, which we have termed as an the fourth part for our convenience, which is the appealable part. Now, only certain provisions which are there after the 112, that the part 10 with regards to the rules, whatever the rules mentioned in all the orders, what is the effect of it. The important term under section 113, the exemptions of the other persons, the following persons shall be entitled to the exemption from the personal affairs in the court. You may read the 113. Section 114 deals with regards to the restitution, application for restitution. If any order has been passed, it has been executed, and if it has been reversed into the appeal, whatever the earlier position is required to be restituted. Section 148A deals with regards to the right to lodge a caveat. Any person who is apprehension that the opposite party may file an appeal or any other proceeding, the concerned person may lodge the caveat requesting to the court that no interim order or any other order can be passed without hearing, giving extending opportunity of hearing to me, and for that purpose, the non-caveator is required to be served the notice of the caveat, and whatever the period for the caveat which has been mentioned in the said that 5, where a caveat has been lodged under subsection 1, such caveat shall not remain in force after the expiry of 90 days from that day on which it was lodged. The important provision under section 151 deals with regards to the saving of inherent powers of the High Court. Nothing in this code shall be deemed to limit or otherwise affect the inherent power of the court to make such orders as may be necessary for the ends of justice or to prevent abuse of the process of court. Abuse of the process of the court. So, section 151 gives the inherent powers to the civil court with regards to the jurisdiction of the civil court. So, as such, we have concluded our entire lecture series with regards to the Code of Civil Procedure. So, to summarize today's lecture, we discussed the fourth part for our convenience with regards to the deals with regards to the appeal provisions. Section 96 to 112, Order 41 to 45, appeal from original decree, appeal from appellate decree, appeal from orders, appeal by indigent person, and appeal to the Supreme Court. Then after we discuss the section 113 and order 46 reference, section 114 and order 47 review, and section 115 revision. 113 gives the exemption, 114 states with regards to the application to restitution, 148A deals with regards to the caveat provision, and section 151 is the saving of inherent powers of the court. As such, I conclude today's lecture. Best of luck to all the aspiring candidates for your examination. Thank you. Thank you very much.
Thank you, sir. Respected Shri Sandeep Munde, sir, distinguished office bearers and members of Akhil Bhartiya Adhivakta Parishad Devgiri Prant, learned advocates, judicial service aspirants, and dear friends, we conclude today's lecture and this wonderful series on the Civil Procedure Code as well as series of lectures on preliminary examination for the post of district judge. First and foremost, I express our heartfelt gratitude to all the respected lecturers and Sri Sandeep Munde sir for guiding us throughout this lecture series with such dedication, clarity, and sincerity. All have devoted their valuable time and share not only legal knowledge but also practical wisdom and experience with all of us. Sole noble intention behind this series is good judges should emerge from among us. Dear friends, the preliminary examination for district judge is scheduled on 10th May 2026, and today's lecture is the concluding lecture for this series for preliminary examination. However, this is not the end of our academic journey. Immediately after the preliminary examination, Akhil Bhartiya Adhivakta Parishad Devgiri Prant will once again begin a new lecture series for preparation of the main examination, so that aspirant may continue to receive proper guidance and support. I also sincerely thank all the participants, advocate, and aspirants who attended this series with enthusiasm and discipline. Your active participation made this lecture series meaningful and successful. I express my gratitude to Akhil Bhartiya Adhivakta Parishad Devgiri Prant for organizing such a valuable academic initiative for the benefit of the legal fraternity and judicial aspirants. Once again, heartfelt thanks to respected Sandeep Munde sir and all other respected lecturers for their valuable guidance and encouragement. Best of luck for the preliminary examination and thank you all. Good night and Shubharatri.